Data subject rights, individual rights, or privacy rights, whatever you call them, these are means for you as an individual to be empowered about questions relating to personal data processing. How? Let's understand this in next few minutes. Hello, my name is Punit Bhatia and I am the founder and CEO of company Fit for Privacy. We are data protection experts and we help you with privacy strategy, its implementation and training for your staff. So in this video, we will look at why do you need rights? What are these privacy rights? And how can you as a company fulfill your obligations in these rights? So let's start with why do you need privacy rights? Let's imagine you as an individual want to ask some questions about your privacy. That is, you want to ask a company what personal data do they collect about you? What do they do with it? Maybe you want to get it deleted. Maybe you want to get it modified. Maybe you want to stop certain automated processing. This is where, from an individual's perspective, privacy rights come in. And these rights empower an individual to ask these questions in a structured manner. That's why in all privacy laws we have individual rights or data subject rights. Why do we call them data subject rights? Because in EU GDPR, the individual, the natural person whose personal data is being processed is referred to as data subjects. That's why we refer to them as data subject rights. That is the rights of the data subject. But I call them individual rights because these are protecting rights of an individual and it is more business friendly. So what are these individual rights? So there are 8 individual rights or data subject rights. So the first one is the right to be informed. So from a company perspective, this is about informing an individual on what personal information is being collected, why it is being collected, what is done with it, who is it shared with, and so on. Now, from an individual's perspective, this is an information that I receive so that I don't have to ask these questions. How does a company fulfill it? You publish a privacy notice or a privacy statement on your website and answer these questions. That's the first level of response. And of course, if someone has more questions, they can exercise their right to be informed and ask more details about their personal information. This is right to be informed. Now, if you need to know about privacy notice or privacy statement, how to create one, what does it contain, you can watch our video on privacy notice. Now the second right is the right to access. That means all the information, all the details you shared about this personal data we collect, this is what we do with it. I want to say, can I have a copy of, can I have access to this data? So when I ask that as an individual, I am exercising my right to access. And as a company, you have to provide me that information which you collected from me and the one you are using about me. Now the third right is right to rectification. That means you have my personal information, I ask you a copy of it, or even otherwise I have changed that information or that information is no longer correct. So I ask you to modify that information, rectify that information. That is, I exercise my right to rectification. This is basically a two-way process. As an individual, I can come to you and say, please modify my data or rectify my data. Or even as a company, you can ask, it has been 1 year since we are having your information. Has this changed? Most banks or insurers usually do it. So right to rectification is about an individual's right to ask for correction or rectification of their personal data. The fourth right is right to erasure. Now this is complex. Right to erasure means I as an individual can come in and ask a company to delete my information. Now of course, if and only if I'm not buying any services and there is no legal reason for the company to keep this data. Not an absolute right, but it provides me as an individual with a provision to ask a company for deletion of my data. Very useful when data is being misused or used unlawfully. If you want to know more about this right to erasure, or also known as right to be forgotten, please do watch our video on right to be forgotten. Now yes, this is easier said than done, and it is complicated, and it is not easy to implement right to be forgotten because systems are not made for deletion and systems do retain data. The right to restrict processing. That means I ask a company to restrict certain processing because I'm not in agreement with them. Or there is a court case going on and I want to stop processing of my personal data till then. Or there's another request like right to object which is ongoing and I want that company to stop processing in the intermediate period. So right to restrict processing is when an individual asks a company to restrict, to limit the processing of personal data in the interim. And as a company, how do you implement it? You implement it by putting in a process to restrict processing when such a request comes in. The next right is the right to data portability. That means you are able to get your data transferred from one company to another company or get it back as you need it in a machine readable format. Now, why do you need it? Well, there is mobile number portability. That means if I move from one provider to another provider, I keep my mobile number, but I change from say Vodafone to 3 or Vodafone to O2 or something like that. If that's happening, it's right to data portability. Now it's very useful. Let's say I have done know your customer checks in one bank and I want to move to another bank. Normally it can be easier. Of course, it's early days and it's still being implemented, but very useful. Right to data portability, that is when you ask for your data to be ported from one entity to another entity so that you don't have to do it, or you ask for a copy for yourself. The next right is the right to object. That means you believe personal data processing is unlawful. If it is unlawful, you as an individual ask that I want to exercise my right to object, and company must stop processing of personal data. Of course, if you ask for that, there must be a very good reason and rational to say that the personal data processing is unlawful. Now there's another right called right to object to automated processing. So example being, let's say you apply for a loan, that loan is rejected based on automated processing, and now your credit score is impacted and your ability to get a loan from another bank is also impacted. So you can object to this by saying, I want this automated processing to be reviewed by a human being. That is, you object to automated processing. So your ability, your right to question automated processing or ask for manual intervention is right to object to automated processing. So we've talked about 8 rights: right to information, right to access, right to rectification, right to erasure or right to be forgotten, right to restrict processing, right to data portability, right to object, or right to manual intervention in case of an automated data processing. Of course, you have the right to complain and also right to withdraw your consent if processing is based on consent. Of course, I can also say that is the right to object. So we talked about why do we need rights, what are these rights, but how can your company comply with these individual rights? Well, the first and foremost is to put in a process wherein you identify these requests and handle them within a stipulated time. For example, in the GDPR, these requests must be handled in 30 days. Of course, you can ask 60 more days, and in the CCPA it is 45 days. So how do you answer these? You put in a process, make sure these rights requests are answered in the time frame that is agreed. You give a confirmation to the individual, you keep them informed, and you answer their request. Well, it does involve collaboration, communication between customer supports, usually IT, legal and privacy teams as well. So you need to put in a process. If you need help with putting in a process, we can help you. Then the other thing is you need to prepare templates so that when these requests are coming in, you are answering them in a structured and standardized way. You also need to keep a register of rights so that you keep a track of how many requests were received, what type they were, when did you receive, when did you answer, and all those details. Another important thing to remember is If I have to exercise my right, I can ask myself as an individual, or I can ask a legal representative to represent me and ask for those rights. Irrespective of who is asking it, your job is to identify that it is the right person. That is, you need to verify identity and then answer the request. As we said, in 30 days if in GDPR, or 45 days in CCPA, or based on the applicable privacy law. So in short, privacy laws provide individuals or empower individuals with data subject rights or privacy rights. There are rights about information, rectification, modification, portability, objection, restriction, and even right to be forgotten. These rights have to be answered within a stipulated time. That's why it's important for companies to answer these in time and be on the right side of the law. If you need help, we can help you. And as I said at the start, we do help companies with data protection expertise. That means we can be your DPO, we can be your EU representative, or we can do a task for you like privacy strategy, doing a privacy assessment, implementing actions or gaps identified from an assessment, and or any specific situation that you may have, like you want to write a privacy notice. For now, keep protecting data, and if you like this video, please do click like, do comment, and do subscribe to our channel. Your support matters and we really appreciate your support. Till next video, thank you so much.